Anthony Del Vecchio, you have pleaded guilty to 24 charges of obtaining a financial advantage by deception. The maximum penalty for this offence is 10 years imprisonment. However, the maximum penalty in respect of charges 7, 16, 23 and 24 is 20 years imprisonment. This is because you are to be sentenced as a continuing criminal enterprise offender in relation to those charges. In sentencing you, I must have regard to the maximum penalties, as these reflect the seriousness with which Parliament regards the offences that you have committed. All but 4 of the charges, being charges 8, 10, 14 and 18, are rolled up. The various sums taken by you in respect of the 20 rolled up charges are set out in Schedules A through to T, which are attached to the indictment. At the time that a number of these offences were committed, you were employed as a service advisor for Freedom Finance Australia, to which I'll refer from time to time as Freedom Finance. You commenced your employment in November 2016. On 26 October 2023, your employment was terminated for misconduct. Between February 2020 and December 2023, you used your position as a financial advisor to convince members of your family, friends and clients to transfer money to you under the pretext that you would invest their funds in various investments such as term deposits, bonds and shares. Each of the victims directly transferred their funds into your bank accounts. In some cases, you provided documents to victims purporting to outline the terms of their non-existent investment. On occasion, you used the Freedom Finance letterhead for these fictitious documents. Between February 2020 and December 2023, you received a total of $4,479,670.56 from the victims. In each case, the victims transferred the money directly into your bank account, and in each case, you never purchased any financial product or provided any service that you had promised to the victims. Instead, you spent their money largely on personal gambling. In sentencing you, I do so on the complete factual basis set out in the amended summary of prosecution opening, dated 17th March 2025, which is Exhibit A. However, in slightly briefer terms, the factual basis is as follows. I come now to rolled up charge 1. The victim in relation to this charge is Luke Narduzzo, who had been a lifelong friend of yours. You had attended the same primary and secondary schools, as well as the same university. Between February 2020 and December 2023, you convinced Mr. Narduzzo to invest in various shares and term deposits, resulting in him making 19 separate transfers to you, totalling $232,913.50. He transferred the funds into your Commonwealth Bank account. You provided documents to him which falsely claimed legitimate investments had been made, but you never made any investments on his behalf. In relation to charge 2, again a rolled up charge, the factual basis for this is as follows. The victim in relation to this charge is your cousin and close childhood friend, Michael Del Vecchio. In October 2021, you told this victim about an opportunity to invest in Flight Centre shares through Freedom Finance. Michael Del Vecchio transferred $7,900 to you for this purpose. Throughout 2021 and 2022, you convinced this victim to invest in various shares and arranged for the funds to be paid into your CBA bank account. You and the victim kept a joint spreadsheet of all these supposed investments. In 2023, the victim wanted to sell his shareholdings because he was purchasing a house with his partner and needed the funds to settle. He repeatedly tried to contact you. Eventually, you transferred him $50,000 over the course of from the 10th to the 12th of April 2023. Shortly after this, you contacted the victim and you told him there had been an error whereby the $50,000 you had sent had come from the wrong account, and you told him that he needed to transfer this back. Between 12th to 14th April 2023, the victim transferred $29,000 back to you. You told this victim there would be tax implications for closing his account and that he should invest in a tax offset investment to minimise tax. On the basis of this advice, between February and August 2023, this victim transferred $82,000 into your bank account. Between October 2021 and August 2023, you received a total of $207,879 from the victim, with the victim receiving $21,000 back from you through the balance of the transfers made in April 2023. In mid-December 2023, the victim heard through a family chat group that you may no longer be employed by Freedom Finance. He contacted the company, who told him that your employment had been terminated in October 2023 and there was no record of his money in their system. In relation to charge 3, another rolled up charge, I was told that the victim in relation to this charge is Tien Nguyen, who is a colleague of yours at Freedom Finance. She was employed as an associate advisor in August 2021. At that time, you held the position of an advisor and you were in Ms Nguyen's team. You initiated discussions with the third victim about investments she could make. You offered her the chance to buy shares in Flight Centre and AGL Energy, which you said you had already purchased at a discount price. Between 26 November 2021 and 3 March 2022, Ms Nguyen transferred to you a total of $4,257.80 in a series of 7 transactions. You told this victim that these would be used to purchase 145 Flight Centre shares and 330 AGL Energy shares. You never purchased any shares for the third victim. Subsequently, Ms Nguyen asked you about the transfer of the shares, but she did not receive a clear reply. In June 2022, she asked you to send the funds back to her with the pretext that she needed them for a trip to Europe. You transferred her $2,066 from 23rd June 2022 to 26 July 2022. In relation to charge 4, a rolled up charge, the victim is Sophia Diaz, who at the relevant time had been your partner in a relationship for about 5 years. In 2022, you began encouraging her to invest in shares and term deposits, telling her that you would purchase these for her through Freedom Finance. Following your advice, Ms Diaz made transfers to you of $3,104 and $10,800. She continued making bank transfers to you for the purpose of buying shares and term deposits. However, again, you never purchased either of these on her behalf. On 4th and 5th July 2023, the fourth victim transferred a total of $35,000 to you to purchase a term deposit with Macquarie Bank. You provided her with a document with a Macquarie Bank logo on it, purporting to evidence the investment. After the purported lapse of the term deposit period in December 2023, Ms Diaz followed up with you. You told her that the principal plus interest would be transferred to her bank through instalments. However, you had never purchased the term deposit. Between January 2022 and July 2023, you received a total of $73,121.26 from Ms Diaz, the fourth victim, who transferred the funds directly into your CBA account. In relation to charge 5, another rolled up charge, the fifth victim is Jessica Macroianis, who was the fiancée of your lifelong friend Luke Narduzzo, the victim of charge 1. In 2021, you helped the fifth victim with purchasing her first home. After receiving a first homeowner's grant, you advised Ms Macroianis of an opportunity to invest with Colonial First State with a 12-month term deposit with a high interest return. In February and May 2022, the fifth victim paid $32,000 into your CBA account, believing this would be used for the term deposit. In January 2023, you further deceived this victim by inducing her to pay a further $60,000 for this purpose. In December 2023, the victim asked to have her investment funds and interest returned. However, you convinced her that the payment platform was holding it back and advised her to invest in a recontribution strategy, suggesting that this would return funds quicker and more easily. The fifth victim transferred a further $30,000 into your CBA account. The total sum of funds which you deceived this victim into paying you was $122,500. As with all the victims, the money was never invested as you represented. The fifth victim did not receive any of her money back from you. In relation to charge 6, a rolled up charge, the victim is Diogo Dias, who is the brother of Sofia Dias, your girlfriend at the time, and who is the victim in relation to charge 4. In December 2022, you told the sixth victim about an investment opportunity for a 30-day term deposit with a high interest return of between 12 to 14%. Between 24th December 2022 and 13th January 2023, Mr Diaz transferred a total of $88,000 into your CBA account in 4 transactions. In February 2023, Mr Diaz made inquiries in relation to an interest payment as this was due. You made a payment to him of $6,890.33, telling him that this was an interest payment which had been earned on the investment. In early 2023, the sixth victim made repeated requests for you to return his money. You paid him a total of $40,103 in 8 transactions between 3rd March and 19th April 2023. In July 2023, you advised Mr Diaz, the sixth victim, about another investment opportunity in a short-term deposit with an interest rate of 15%. Mr Diaz transferred $30,000 into your CBA account. After a number of requests were made by him for the return of the funds, you transferred $80,000 to him from your CBA account. In total, you obtained $118,000 from Mr Diaz between 24th December 2022 and 21st July 2023. In relation to charge 7, a rolled up charge, the victims are Catherine and Anthony Sims, a married couple who are clients of Freedom Finance. They met you in 2022. Catherine Sims was a 60-year-old teacher. She had sought advice about structuring her superannuation and retirement funds. In February 2023, you offered financial advice regarding an investment in bonds with a high interest return. You went to the home of the victims and convinced them to transfer you $60,000, saying that this was for a 12-month term deposit with a high interest rate of return. On 10th February 2023, the victims paid $60,000 from their bank account into your CBA account. However, you never purchased the term deposit for them. At the end of October 2023, you convinced the victims to transfer you a further $33,000 on the pretence that this would be used to purchase bonds. However, you did not purchase these either. On 22nd December 2023, Mr and Mrs Sims were told that the funds they had invested had been misappropriated by you and had never been invested in any term deposit. In total, you obtained $93,000 from these victims between 10th February and 21st November 2023. In relation to charge 8, I was told that the victims are Paul Morrison and Eleanor Cummins, who had been clients of Freedom Finance since September 2020. You had been recommended to them by friends who had also been your clients. The victims agreed to transfer $29,000 to you upon you representing that you would invest this for them and that this would yield high interest over a 6-month period, coming to maturity in October 2023. However, in December 2023, the victims were advised by Freedom Finance as to your misappropriation of clients' funds and the investigation into your offending. In relation to charge 9, a rolled-up charge, the victims are your cousin, Francesco Del Vecchio, and his wife, Francesca Del Vecchio. On 3rd March 2023, you visited the victims at their home and told them about an opportunity to invest through Freedom Finance. Taking your advice, the victims invested $60,000, transferring funds into your CBA bank account. You told the victims the bank account was a clearing account in your name, and once cleared, the funds would be transferred into the Macquarie bank account, which, I understand, was associated with the purported investment. In July 2023, you attended the victim's home and convinced them to transfer you a further $40,000, saying this would be invested into a high-interest bearing account. A few days after this, you told the victims that their $60,000 investment was reinvested, and you convinced them to transfer you a further $20,000 under the pretence that this would also be invested. On 13th December 2023, you went to the victim's home and convinced them to transfer you a further $180,000, saying that this was for an investment that would earn them $24,000 in interest. At this time, you were no longer employed by Freedom Finance and you were not licensed to be an authorised representative. Between 3rd March and 17th December 2023, you obtained a total of $300,000 from Francesco and Francesca Del Vecchio. In relation to charge 10, the victim is your cousin, Alana Del Vecchio, with whom you had grown up. Your families were very close. On 19th March 2023, you convinced Alana Del Vecchio to transfer to you $25,000 under the pretence that this would be used to invest in a short-term deposit with 8.9% interest return through Freedom Finance. However, again, you never purchased any such financial product for the victim. In relation to charge 11, a rolled-up charge, the victim is Melissa Rubin, who is a member of your extended family whom you had known your whole life. On Monday, 20th March 2023, you told Ms Rubin of a term deposit with Macquarie Bank, which had a 9% interest return. On the basis of your advice, Ms Rubin invested $35,000, transferring the funds into your CBA bank account. In July 2023, you deceived the 11th victim into investing another $8,999, again transferring funds into your CBA account. This made a total of $43,999 that you had purported to invest. In November 2023, you went to the victim's home and provided a copy of a document outlining the supposed investment of $44,000 with an interest rate of 9.21%. Ms Rubin told you that she needed to withdraw funds in the first week of December 2023. However, you convinced Ms Rubin to maximise her return by adding more funds to the investment. Ms Rubin then transferred $2,000 into your CBA account, which was at a time when you no longer worked for Freedom Finance. In total, between 20th March and 16th November 2023, you defrauded the 11th victim to the extent of $45,999. In relation to charge 12, a rolled-up charge, the victims were friends of yours, Paula and John Cooner. In April 2022, you engaged in a conversation with Paula Cooner regarding your employment with Freedom Finance, and you offered your services in relation to any financial needs in the future. On 22nd March 2023, you attended the victim's home and told them of an investment into a short-term deposit with an 8.2% interest return. The victims believed you and signed contract documents provided by you. they transferred $60,000 into your CBA account. A few days later, you convinced the victims to transfer a further $170,000 under the pretence that this would go into a 90-day term deposit with Macquarie Bank with 5% interest return. However, as with all the victims, you did not invest the money at all, but you used it for your own benefit. In relation to charge 13, a rolled up charge, the victim in this matter is Alex Kuna, a lifelong friend of your former girlfriend Sophia Diaz. Through this connection, you and Alex Kuna became friendly. In March 2023, you attended the 13th victim's home and told him about an investment opportunity in a 12-month term deposit. The 13th victim then transferred $50,000 to you for this purpose. In April 2023, you convinced the victim to invest a further $17,000 in a short-term deposit with a 10% interest return. In May 2023, you transferred $1,652 into this victim's bank account, advising him that the funds were from interest earned on his $17,000 investment. When questioned about the return of the $17,000 principal, you convinced Alex Kuna to reinvest the funds for another 28 days with higher interest and to invest an additional $3,000 to gain a better return on his investment. Believing you, this victim transferred another $3,000 into your CBA account, making a total of $20,000. In September 2023, you again convinced this victim not to require the return of the $20,000 on the pretence that it would be reinvested with a high interest rate of 9% return. The victim told you he was planning on travelling to Europe. However, you convinced him that more funds paid into the investment would allow him to obtain more money for his overseas trip. The victim then transferred another $15,000 into your CBA account, making a total of $35,000. Between March 2023 and September 2023, you received a total of $85,000 from this victim. In relation to charge 14, the victim is Melanie Kuna, a lifelong family friend of your former girlfriend Sophia Diaz. Melanie Kuna had known you for about 6 years. In April 2023, you advised her of an investment opportunity in a 3-month term deposit with a high interest return of 8.76%. As a result of this, Ms. Kuna transferred $30,000 into your CBA account. However, she did not receive funds at the time the supposed investment should have matured. After a number of phone calls to you, on 2nd November 2023, you transferred $1,000 into this victim's account, advising that there would be a further return. However, again, you'd never purchased the financial products and the victim did not receive any repayment. Charge 15, a rolled up charge. The 15th victim is Helen Rossiter, who is a client of Freedom Finance. From November 2022, you had been her financial advisor, advising her on her pension fund and other financial arrangements. On 13th April 2023, you advised this victim of an investment opportunity in a bond with a high interest return. The victim then transferred $70,000 into your CBA account. Between September and December 2023, you convinced this victim to invest a further $280,000 from her pension fund. By November 2023, you no longer held a financial services licence as your authorisation and employment with Freedom Finance had been terminated on 18th of October 2023. The victim transferred funds into your CBA account, not being aware that your employment had been terminated. Between April 2020 and December 2023, you received a total of $353,000 from this victim, who paid the funds directly into your CBA account. In relation to charge 16, the victim is Benjamin Szabo, who was a family friend. On 15th April 2023, you contacted Mr. Szabo through Facebook and told him about an opportunity to invest in a term deposit investment with a rate of 9% interest. Between 17th and 24th April 2023, this victim made 4 transfers to you, totalling $400,000. You provided a copy of a document entitled Freedom Finance Australia Advice Deposit, which falsely claimed an investment had been made on Mr. Szabo's behalf. In May 2023, you told the victim about a further investment opportunity for a term deposit. Mr. Szabo then transferred a further $650,000 to you for this purpose. Again, you provided a false document entitled Freedom Finance Australia, purporting to record a deposit and which falsely claimed that $650,000 had been invested on the victim's behalf. In July 2023, Mr. Szabo had a meeting with you where he asked about the return of his investment. You told him that to release the interest, a payment referred to as a tax wash payment needed to be made. Between 19th July and 8th September 2023, this victim transferred a total of $148,000 to your bank account for this purpose. Subsequently, the 16th victim made a number of requests to you for the return of his money. He told you he needed the money to make an offer to purchase a particular commercial property that he had in mind. On 28th September 2023, the victim sent an email demanding a written timeline for the return of his investment and threatening legal action. On 3rd October 2023, you replied with a timeline for returning the purported investments. On 6th October 2023, the victim purchased the commercial property and contacted you, saying he needed the funds to avoid defaulting. Between 17th April and 8th September 2023, you obtained $1,198,000 from Benjamin Szabo, and he never received any money back. Again, you never purchased any financial products for this victim. In relation to charge 17, a rolled up charge, Toby Wilson is the victim in relation to this charge. He worked with you at Freedom Finance. By 2023, Mr. Wilson had left Freedom Finance but remained friends with you. You are also Mr. Wilson's financial advisor. In June 2023, you contacted this victim and advised him of an investment opportunity in a term deposit with a 21.7% interest return. You advised that the investment was to be through a business owned by your uncle called Waterworks. Mr. Wilson agreed to transfer $15,000 into your account. As usual, you made no such investment. When Mr. Wilson contacted you at a time when the investment was supposed to mature, you made a number of excuses for not repaying the money. On 15th September 2023, you paid $1,575, indicating this was a partial interest payment on Mr. Wilson's investment. A few days later, you asked him if he would be interested in further investments, as your uncle was selling his business and this would be the last opportunity to invest. Mr. Wilson then transferred $35,000 to you. On 23rd September 2023, you contacted this victim, advising that there was capacity for a further investment of $10,000 and that you would cover $8,000 if the victim would invest a further $2,000. The victim then transferred a further $2,000 into your account. Therefore, you obtained a total of $62,000 from Toby Wilson between 4th July and 27 September 2023. I was told by the prosecution that $10,000 was returned to him. I was told that even though the total financial advantage obtained by deception was $62,000, the charge in relation to this victim had been resolved on the basis that the financial advantage obtained was $52,000, apparently allowing for the repayment of $10,000 in this particular instance. In relation to charge 18, The victim is Lewis Orr, who is a colleague of yours at Freedom Finance. You were also Mr. Orr's financial advisor. In June 2023, you and Mr. Orr had a conversation about an opportunity to invest in a short-term deposit. Investment was to be through your uncle's business, Waterworks. On 6 July 2023, Mr. Orr transferred $15,000 into your account. Again, no investment was made. When the victim contacted you in relation to the supposed maturity of the investment, you made a number of excuses to avoid repayment of any funds to him. On 15 September 2023, you paid $1,575 to this victim, saying that this was a partial interest payment on the investment. You convinced this victim that you would roll over the outstanding $15,000 from the previous investment into another investment opportunity for a period of 27 days with 28% interest return. When that purported investment was supposed to mature, Mr. Orr made a number of inquiries with you. You continued to make excuses, but you did not repay the money. Therefore, you obtained a financial advantage of $15,000 from this victim on 6 July 2023. In relation to charge 19, a rolled-up charge, the victim is Manuel Diaz, the father of your then-girlfriend, Sophia Diaz. In July 2023, you convinced this victim to invest into a term deposit with Macquarie Bank with a high interest return. Mr. Diaz invested $60,000, transferring the funds into your CBA account. The investment was supposed to be for a 40-day period. When that period had elapsed in November, the 19th victim made a number of attempts to have you return the investment. After saying he would go directly to Freedom Finance, you transferred $56,139 into his bank account in a series of transactions between 24th October and 29th November 2023. Therefore, the victim in this matter paid you $60,000. In relation to charge 20, rolled up charge, the victims are Gary and Carolyn Smithett, who are clients of yours through Freedom Finance. In August 2023, you attended the home of these victims and discussed an investment in a term deposit with a high interest rate. You advised the victims that if the funds were transferred into your Freedom Finance account and combined with other investors, the larger amount of funds would attract a higher interest return. Acting on this advice, the victims transferred a total of $428,000 to you between 17th August and 4th October 2023. You provided the victims with documents containing the Freedom Finance logo, which stated that the money had been invested. However, no such investment had been made. In December 2023, Mr. and Mrs. Smithett were told by Freedom Finance that you no longer were a financial advisor working for them and there were problems with your behaviour relating to clients. Therefore, these victims paid you a total of $428,000, which went into your CBA account, none of which was returned. In relation to charge 21, a rolled-up charge, the victims are Erta and Fabio Rubin, who are your third cousins. They knew that you were a financial advisor and worked at Freedom Finance. In August 2023, you went to the victim's home and told them about an investment opportunity in a term deposit with a high interest return. As a result of your advice, these victims transferred $70,000 to you, believing they would receive 10.39% interest return over 90 days. You provided the victims with paperwork outlining the terms of the investment, but again, you made no investment for them. Therefore, between 21st and 25th August 2023, you obtained $70,000 from your third cousins. In relation to charge 22, a rolled-up charge, the victim is Anthony Pucci, who is a distant cousin of yours but is closely connected to your family. On 24th September 2023, after sending his wedding invitation to your parents, you sent a message to Mr. Pucci telling him of an investment opportunity that would make him money for his wedding. On 25th September 2023, You attended at the victim's home and told him of a term deposit with Macquarie Bank. You advised Mr Pucci that the investment was a term deposit for 42 days and would earn 11% interest. Mr Pucci transferred $80,000 into your CBA account, but no investment was made by you. In December 2023, Mr Pucci was advised by family members of your termination of employment and that the funds had never been invested. In relation to charge 23, a rolled up charge, the victims are Nicola and Amy Matza, who are family friends of yours. While Nicola and Amy Matza were on an overseas trip, you contacted them or connected with them via Facebook. When they returned, you telephoned them and told them that there was an investment opportunity with Freedom Finance. You convinced these victims to invest in a high interest opportunity of 10 to 11% deposit for 45 days. Between 11th October and 17th October 2023, the victims transferred a total of $250,000 into your CBA account. Subsequently, numerous attempts were made to contact you and inquire about the investment without success. When the victims contacted Freedom Finance, they were told you'd been terminated and there was no record of any such investments made by you. In relation to charge 24, a rolled up charge, the victims are Bradley and Helen Rossiter, who were referred to you by Helen Rossiter. You became their financial advisor through Freedom Finance. On 17th October 2023, you met with the victims and convinced them to invest in a term deposit with a high interest return. On 18th October 2023, you had your authorised representative licence and employment suspended by Freedom Finance as previously stated. On the same day, you provided these victims with documents outlining their investment, which appeared to be legitimate documents from Freedom Finance. The victims transferred $380,000 to your CBA bank account in a series of transactions between 19th October and 7th December 2023. During the month of December 2023, the victims made attempts to contact you and inquire about their investment. However, you avoided them. On 27 February 2024, you were arrested and interviewed by police. During your interview, you generally made admissions in relation to the offending. You also said the following things. A, that you worked at Freedom Finance for 7 to 8 years as a financial advisor. B, you would often give advice to people to get them to make deposits and use the money to gamble and pay other people back. C, you would talk to people and offer high rates to get them to transfer money to you. D, you started full on, as you said, gambling last year. E, the majority of funds were sent to your personal bank accounts. F, you said you were in too deep and the stress was incomprehensible. G, when you transferred money back to some of the victims, your intention was to repay them, not to induce them to make further transfers. H, you were trying to win enough money to pay everyone back. A subsequent analysis of your bank accounts and other financial documents by a forensic accountant on 12 August 2024 resulted in the identification of $4,478,100.51 as being deposited into your CBA accounts between 13th February 2020 and 18th December 2023. The forensic accountant also identified that you had $9,949,715.87 in credits from betting and $13,228,269.90 in withdrawals from betting. The betting transactions related to a series of 52 different betting companies. I intend to name some of these companies and give further details in relation to the forensic accountant's report in due course. Mr Del Vecchio, your offending is most serious and deserving of a punishment which is just in all of the relevant circumstances. Your conduct must be strongly denounced. In assessing the seriousness of your offending, I've taken into account that it endured for over 3 years, which is a substantial period, and involved a substantial number of victims who, in most, if not all cases, could ill afford to part with the sums of money that they did. In the main, the individual sums which you took were most substantial. The total sum that you stole was vast. You breached the trust that the victims placed in you as a financial advisor and, in many instances, as a friend and or family member, callously taking advantage of such relationships to commit the offences. The significant breach of trust is an aggravating feature of your offending. Further, the offending was planned and had a level of sophistication to it in a number of instances, especially where you used false documents and manufactured investment schemes and the like in order to defraud the victims. Further, in a number of instances, the offending went beyond opportunistic, as you actively sought out your victims, knowing full well they could ill afford to part with such significant sums of money, which in a number of cases were their life savings. You chose to do so on occasion, knowing that particular victims had particular needs for their hard-earned money, but apparently your need to gamble or use the money for your own benefit was your priority. I accept that you had a raging gambling addiction, especially as time wore on. However, this is an explanation rather than any excuse or matter in mitigation, which was accepted by your counsel. In a number of instances, you were persistent, returning to some victims in order to further defraud them. Whilst you did repay some money to some victims, the only significant repayment of the money that you effectively stole was to Diogo Dias and Manuel Dias. Vast amounts remain outstanding. As to whether you genuinely intended to repay the victims by deludedly believing you could recoup your losses from gambling is far from clear, despite what you told police. I suspect that you made some repayments to ensure that your offending was not discovered, but I will put my suspicions to one side. What is clear is that you were in the grips of a gambling addiction, which you were prepared to feed by any fraudulent means that you could. The addiction explains your behaviour, but it does not excuse it or impact on your moral culpability. The objective seriousness of your offending is high, as is your moral culpability. I take into account the impact on the victims in this matter, a number of whom prepared victim impact statements. I have read each of the victim impact statements in this matter, and a number of victims read their statements aloud at the plea hearing, while some had the learned prosecutor read their statements to me. Whether read aloud or not, I have taken each of these victim impact statements into account. In all, the impact to the victims who provided victim impact statements has been nothing short of devastating and has profoundly impacted their lives and well-being, not only because of the loss of the various sums of money that you deprived them of, but also because of the hurt and betrayal of trust involved in your offending. A number of the victims have also been negatively impacted by the loss of contact with family members who have supported you. Effectively, your extended family, which was once a very close and happy unit, has imploded. Some victims also spoke of feeling especially hurt because of you knowing about their vulnerable situations. In particular, one victim said that you offended against her at a time when you knew that her daughter was being treated for cancer. Others spoke of your awareness as to their need of the money that they entrusted to you and spoke of the hardship that they were enduring without the funds that they had given to you to invest. As I said at the plea hearing, although a number of the victims have expressed feelings of humiliation, shame and guilt for being taken in by you, the only person who should be feeling such emotions is you, Mr. Del Vecchio. You have no prior convictions, which is a matter in your favour, although this is against a backdrop of over 3 years of offending and being in a position to offend because you were a licensed financial advisor working for a legitimate company offering such services. You continued to offend even after losing this position. Having said all of this, I have taken into account in your favour that you have no prior convictions, as I must do. I do not take the step of finding that your offending is aggravated by you using your good character to commit the offences. You use your position of trust in order to commit the offences, as I've said. I take into account your background. At the time of the offending, you were aged between 26 and 30. You are now 32 years old. Your family consists of your father, mother, and younger sister. Each of these people and others were in court in support of you at the plea hearing. It is evident that you are well supported in the community, which is a matter in your favour, as this is relevant to your prospects of rehabilitation, specific deterrence and protection of the community. You were educated in Melbourne, completing secondary school with an ATAR of 95. You then went to Deakin University and completed a Bachelor of Commerce. Your formal employment post-university has been as a financial advisor. I was told that in 2019 you developed a gambling addiction, which began with online racing and sports betting across multiple providers. Initially you were gambling approximately $100 per week, but this grew over time. Inevitably you lost money, so made the decision to use your clients' funds to try and chase the losses you had incurred. However, the losses escalated, leading to further offending, with you seeking to claw back those losses. Towards the end of the offending period, the amounts being gambled were in the thousands per bet, with multiple bets being placed every day. The availability of the gambling apps on your smartphone meant that your access to offending behaviour was, to quote your counsel, at your fingertips. I was told that you were allocated a specific client manager or VIP manager by some of the gambling providers. I asked your counsel to provide me with details in relation to this, which are now to hand by way of further submissions. In further written submissions dated 28th March this year, Mr Menon told me that there were approximately 8 to 10 betting companies that offered you, in inverted commas, relationship or in inverted commas, VIP managers. You said that you could not recall the names of any of the individuals you dealt with or all of the companies that offered this so-called service, but you clearly recalled that such people were offered by the following betting agencies. A company called Neds. B, Ladbrokes. C, PointsBet. D, TAB. E, MintBet. F, Bluebet. You said that your assigned relationship or VIP managers would contact you very soon after you placed larger bets with their agency. Contact would be made by text or phone, with some agencies contacting you daily. These individuals would offer you tickets to sporting events as well as bonus bets, which I understand you would accept. If you were successful in a wager, you would often be sent a text almost immediately after the win, offering a way to, in inverted commas, reinvest it. I was told that if you did not place a bet or deposit money for a short period of time, you would receive push notifications offering you deals to encourage further bets and deposits. As you deposited greater amounts and made more serious wagers, there was never a time when any gambling service questioned your conduct. No limits were placed on any bets made by you, nor on any deposits. It is apparent from the forensic accountant report, which was prepared in this matter, that from 13th February 2020 to 4th January 2024, you were engaged in gambling with 52 different betting outlets, with MintBet at the top of the list of highest to lowest net fund outflows. I refer to paragraph 27 of the forensic accountant report. In relation to MintBet, the sum of withdrawals during the period to which I've just referred was $2,261,736, and the sum of credits or deposits was $1,247,976.60. Next, from highest to lowest, is TAB, with the sum of withdrawals being $2,566,815, with deposits or credits shown as $1,649,546. Next is PointsBet, indicating $2,872,711 worth of withdrawals and $2,130,246 worth of deposits or credits. Number 4 on the list is BetNation, with withdrawals of $1,035,500 and $604,743 credits. Number 5, Neds, $1,021,899 in withdrawals and credits or deposits of $791,149. At number 6 is Ladbrokes, with withdrawals totalling $964,035 and credits of $735,832. At number 9 is CrossBet, with $235,780 worth of withdrawals and $106,217,000 worth of credits. Next is Bluebet, with $270,599 worth of withdrawals and $178,994 in deposits or credits. Next is PalmerBet Pty Ltd, $294,791 withdrawals and $212,858 in deposits or credits. At number 14 in the list from highest to lowest is Southern Cross Bet, $109,920 in withdrawals and $91,977 in credits or deposits. Elite Bet, $97,980 withdrawals and $87,763 deposits. VicBet, $16,700 withdrawal and $11,433 worth of deposits or credits. There are other entries in this list in the thousands and tens of thousands of dollars, including at number 48, WishBet Australia, $81,950 withdrawal and $90,506 deposit, and GoldBet, $547,900 withdrawal and $560,160 credit or deposit. As said, the total net fund outflow was negative $4,278,553.93. Table C of this forensic accountant's report in its entirety will be annexed to my sentencing reasons, as it demonstrates the extraordinary sums of money involved in your gambling, money which was not yours for the most part, and it also reveals the various betting agencies who were apparently happy to take that money without any qualm or inquiry. Such business practices by these betting companies embody the expression, the banality of evil, in my view, and is staggering that they are able to operate in our community in the ways that I've described with impunity. So much for the slogan, gamble responsibly. I was told that after your offending was discovered, you commenced gambling counselling in December 2023 with a Ms. Soketa Jim, a therapeutic counsellor with Better Health Network. You commenced weekly appointments which eventually stretched to fortnightly ones. I've taken into account the letter from Ms. Chim dated 14th March this year. You presented to that service in December 2023 with concerns about problem gambling and declining mental health. You then engaged in counselling sessions in January 2024 and consistently attended regular sessions every week, then fortnight. The letter says that your therapy was focused on reducing symptoms, which were said to underlie your gambling addiction and which helped to regulate your emotions and other aspects of your life, including abstaining from gambling. You engaged in cognitive behavioural therapy as well as other therapies. You reported that you had achieved your therapeutic goals and attended your final session with BHN in March 2025. You also received counselling for your mental health from a Dr. Beirutz Mali, consultant psychiatrist. Such counselling directed towards your anxiety and gambling disorder in the main. You have received medication to address your symptoms of anxiety. However, I understand that your anxiety has somewhat moderated in intensity. I have read and considered Dr. Marley's report. He has treated you professionally for a number of months now. He conceded that he is not an independent forensic report writer, but as your counsel indicates, he does have the benefit of having worked with you in a therapeutic context for a longer period of time than might otherwise be the case. I have taken into account Dr. Marley's report in a general way, although noting that he is not a forensic psychiatrist and has not conducted any proper testing in relation to assessing your risk of reoffending. He was of the view that your childhood and personal experiences, which included high expectations and the pressure to achieve, may have contributed to your vulnerability to anxiety and escapism through gambling. The emphasis on may is mine. He is of the view that you meet the diagnosis of gambling disorder and anxiety. He appeared to be of the view that your resort to gambling was a maladaptive coping mechanism. However, it was not submitted that there was any impairment of mental function which would serve to reduce your moral culpability, which, as I've previously found, is high. Your counsel submitted that your anxiety, whilst being well managed now, would likely be stimulated in a custodial setting and make your time in custody more difficult than someone without such a condition. However, it was submitted that the mitigation was likely toward the lower end. I accept that you do suffer from anxiety, which has been well managed in the community, but may well exacerbate in a custodial setting, making your time in custody more difficult than would otherwise be the case. However, I make a fairly marginal allowance in this regard in circumstances where your state of anxiety is or has been fairly stable and moderated. However, I do note that this is your first time in jail and that for this reason, time in custody will be harder for you than for a more seasoned prisoner. I accept that you made substantial admissions to the police in your record of interview and entered pleas of guilty at the earliest possible stage. In these circumstances, the law provides that you are entitled to a significant discount in the sentence you would otherwise receive, as you have saved the witnesses the time and trouble of giving evidence, and you have saved the community the time and expense of contested proceedings. It was submitted that you are remorseful for your conduct. This is somewhat complicated in circumstances where you actively engaged in this conduct, persistently approaching victims, and you did not see fit to stop until your offending was discovered, having offended over the course of approximately 3 years or more. I also factor in that you had a gambling addiction and that, like many in such situations, you may have foolishly believed that you would be able to bet your way out of the increasingly serious debts that you were incurring using the victim's money to keep going. At times, you did make some effort to make some repayment to some of the victims, although this was rather insubstantial in most cases, and I'm not satisfied in the balance of probabilities that these efforts sprang from feelings of remorse. However, having been caught by police, you made admissions, pleaded guilty at an early stage, and have expressed remorse to various of the character referees and material from your treating professionals. You also belatedly provided a letter of apology to the court, which I've considered. In that letter, you offer your sincere and heartfelt apology to the victims, and you acknowledge the harm you have caused them, both financially and emotionally. In that letter, you say you will continue to make every effort to rectify your wrongs, whether through restitution or other means, and that you are committed to proving that you are capable of change. You attribute your offending to your gambling addiction, for which you have sought professional help. Although your letter is of a somewhat self-serving nature and provided very late in the piece, I accept that you have expressed remorse to others in accordance with the material before me. In the end, I accept that you are remorseful for your offending and have some insight into the seriousness of what you have done, but in my view, these are both works in progress. When you are released from jail, it is to be hoped that you keep to your word and engage in honest hard work to repay the victims. I've taken into account the character references insofar as I can, and I've factored in that you have been an invaluable volunteer at Power Neighbourhood House over the past 2 years, becoming an integral part of their community. I am concerned that the particular referee from that organisation does not indicate an awareness of your offending and indeed refers to you as having a strong moral compass, which I'm afraid is not consistent with the offending for which I now sentence you. I've also factored in your volunteer work with Ben's Place and the character reference written in support of you in relation to that voluntary work. Putting aside the lengthy period during which you offended, I find that you are a person of otherwise good character, which is a matter which counts in your favour. Your counsel submitted that in view of the gains you'd made in the past year since your offending, including your counselling and psychiatric treatment, that your prospects of rehabilitation were excellent. In my view, taking into account the nature of your offending, its duration, but also factoring in your lack of criminal history, your efforts towards rehabilitation, as well as your early pleas of guilty and cooperation with the police, as well as your developing insightful remorse, I assess your prospects of rehabilitation as being quite good. Much will depend upon your ability to maintain abstention from gambling. I've also factored in that you will be unable to be a licensed financial advisor ever again and that jail will be a salutary experience for you. I place less than moderate weight on specific deterrence and protection of the community. However, I place strong weight on general deterrence in a bid to deter others from behaving as you have. Your counsel provided me with a table of other cases, and the prosecution also provided me with some other cases in respect of current sentencing practice. I've had regard to these cases, bearing in mind that current sentencing practice is but one sentencing consideration and not a controlling one. It is accepted by you, most sensibly, that nothing short of a head sentence with a non-parole period is warranted. Your counsel, Mr. Menon, submitted that the sentence I impose ought not be crushing and to have due regard to the principle of totality in sentencing you, adjusting cumulation to accommodate for this. The prosecution submitted that a head sentence with a non-parole period was warranted and that a large gap between the head sentence and non-parole period was not, in all of the relevant circumstances. I have applied the principle of totality in your case, which has meant that fairly modest periods of cumulation have been directed and only in respect of some of the charges. I must also bear in mind that although you are not a youthful offender, you are still quite young, and I ought to do what I can in the circumstances to promote your prospects of rehabilitation, which is something that will not only assist you, but help protect the community from further offending by you. In my view, in all the relevant circumstances, it is appropriate to provide for a rather large gap between the head sentence and non-parole period in your case. You are convicted of the offences. On being found guilty of charge 23, you stand to be sentenced as a continuing criminal enterprise offender in relation to charges 7, 16, 23 and 24. It will be entered into the court records that you are being sentenced as such in relation to each of these offences, where the maximum penalty is 20 years imprisonment, due to the fact that each of these rolled up charges includes a single transaction where a financial advantage that you obtained was $50,000 or more. You are sentenced to the following periods of imprisonment. Charge 1, 2 years. Charge 2, 2 years. Charge 3, 2 months. Charge 4, 10 months. Charge 5, 18 months. Charge 6, 12 months. Charge 7, 13 months. Charge 8, 5 months. Charge 9, 3 years. Charge 10, 5 months. Charge 11, 6 months. Charge 12, 2 years. Charge 13, 10 months. Charge 14, 5 months. Charge 15, 3 years. Charge 16, 5 years, 4 months, which will be the base sentence. Charge 17, 6 months. Charge 18, 4 months. Charge 19, 5 months. Charge 20, 4 years. Charge 21, 9 months. Charge 22, 10 months. Charge 23, 2 years, 8 months. Charge 24, 3 years, 8 months. As I've said, the sentence on charge 16 is the base sentence. I direct that 2 months from the sentences on charges 1, 2 and 12, 1 month from the sentences on charges 5, 6 and 7, 3 months from the sentences on charges 9, 15 and 23, and 4 months from the sentences on charges 20 and 24 be served cumulatively with each other and with the base sentence, producing a total effective sentence of 7 years, 6 months imprisonment. I direct that you serve 4 years imprisonment before becoming eligible for parole. I declare that you have already served 28 days by way of pre-sentence detention. If not for your pleas of guilty, I would have sentenced you to a total effective sentence of 9 years, 6 months, with a non-parole period of 6 years, 6 months.